Ready guys, 10 seconds to go. 5. That the cause of action accrued in favor of the plaintiff and against the defendant when she invoked jurisdiction of the US court after having submitted the jurisdiction of the Indian court in various proceedings and verifying a petition for divorce on the same day for the Indian court. Stop. It is apparent that the plaint cannot be rejected on the basis of the allegations made by the defendant in his written statement or in an application for rejection of the plaint. Stop. The court has to read the entire plaint as a whole to find out whether it discloses a cause of action, and if it does, then the plaint cannot be rejected by the court exercising the powers under Order 7, Rule 11 of the Code. Stop. Essentially, whether the plaint discloses a cause of action is a question of fact which has to be gathered on the basis of the averments made in the plaint in its entirely, taking those averments to be corrected. Stop. A cause of action is a bundle of facts which are required to be proved for obtaining relief, and for the said purpose the material facts are required to be stated, but not the evidence, except in certain cases where the pleadings relied on are in regard to misrepresentation, fraud, willful default, undue influence, or of the same nature. Stop. So long as the plaint discloses some cause of action which requires determination by the court, the mere fact that, in the opinion of the judge, the plaintiff may not succeed cannot be a ground for rejection of the plaint. Stop. In the present case, the averments made in the plaint, as has been noticed by us, do disclose the cause of action, and therefore the High Court has rightly said that the powers under Order 7, Rule 11 of the Code cannot be exercised for rejection of the suit filed by the plaintiff. Stop. The expression cause of action has acquired a judicially settled meaning. Stop. In the restricted sense, cause of action means the circumstances forming the infraction of the right or the immediate occasion for the reaction. Stop. In the wider sense, it means the necessary conditions for the maintenance of the suit, including not only the infraction of the right but also the infraction coupled with the right itself. Stop. As noted above, the expression means every fact which it would be necessary for the plaintiff to prove if traversed in order to support his right to the judgment of the court. Stop. Every fact which is necessary to be proved, as distinguished from every piece of evidence which is necessary to prove each fact, comprises in cause of action. Stop. The expression cause of action has sometimes been employed to convey the restricted idea of facts or circumstances which constitute either the infringement or the basis of a right, and no more. Stop. In a wider and more comprehensive sense, it has been used to denote the whole bundle of material facts which a plaintiff must prove in order to succeed. Stop. These are all those essential facts without the proof of which the plaintiff must fail in his suit. Stop. The expression cause of action is generally understood to mean a situation or state of facts that entitles a party to maintain an action in a court or a tribunal, a group of operative facts giving rise to one or more bases of suing, a factual situation that entitles one person to obtain a remedy in court from another person. Stop. A cause of action is stated to be the entire set of facts that gives rise to an enforceable claim. Stop.